Greetings all. Welcome once again to Hein's webinar. It's our regular deep dive into the weird, wonderful world of strata and management rights in Queensland. My name is Chris Hines. I'm Director of Strata Solve. That's stratasolve, or one word, .com.au. And as always, I am joined by Frank Higginson, partner at Hines Legal, the premier provider of legal advice in the strata industry in Queensland. Welcome, Frank.
Hello, Chris. Hello, everyone. Again.
Greetings all. Frank, what's been happening? What's going on?
Mate, the usual. It just doesn't stop, this strata industry, and I suppose looking for something different, that's not it. You know what I mean? Probably the thing that is really interesting, we're still going through the property law reform process and legislation and acts and all that sort of thing. To be honest, in the last couple of weeks, there's been some things pop up that aren't on the reform agenda that could quite possibly be on the reform agenda, and I'm wondering how to get them on. So that, you probably tell me more about that, having been a former government employee, but I think, yeah, it's just a couple of things, as always, that appear that, hang on a minute, that's important. But then I suppose the question is, it's all important, and there's only so much bandwidth to deal with, and we can't go and change every single piece of legislation to deal with whatever the latest issue of the month is. But mate, it's constant.
I don't think you're alone there, Frank. I've had that thought myself a couple of times recently, and then I've had it presented to me through very different random topics from others as well. It's always about priority, isn't it? You know, you want to fix everything, but you can't fix everything. Certainly, you can't fix it all at once. So, what goes first? What goes second? And so on and so on and so on. Today's topic might be kind of a good example of that sort of thing, where this, and we'll get to that in a moment, where does this fit into the grand scheme of things? But before that, just a bit of housekeeping for everybody. For those listening in live and our YouTube channel, you can post your questions in the chat. We welcome that, don't we, Frank? We love those questions.
Absolutely. No, it keeps us on our toes every time.
Absolutely, it does. So chuck them on in, and we'll endeavour to answer those. For those listening later on via the podcast, when you're out walking the dog or washing the dishes or whatever you're doing, you can find all the notes and links that we refer to on the Hines Legal YouTube channel, or just at hineslegal.com.au. This week, Frank, I'm trying to weave in a few more musical references to our podcasts. And today, with very sincere apologies to the late, great David Bowie, it's Mould-en years. Sorry, David, wherever you are.
Yeah, he'll be highly offended. You're an idiot.
I suspect he would dryly laugh at that one. But yeah,
there's another pun.
Yeah. Thank you. It's yuck. It can cause a lot of problems, can't it, Frank?
Absolutely. And it's one of those things that I never really understood the safety elements or the personal harm elements that can come with mold until one particular experience, which we'll probably talk about in a minute. But it can be really dangerous. And I suppose it's sort of in legal circles, you know, you always get this battle between issues that affect you, particularly because of your personal health circumstances, as against issues that would just affect the average person in a different way. And I think in the world of strata, you know, we've got 550,000 strata lots in Queensland, and we're coming back to acting reasonably and all that sort of stuff. I don't necessarily think that anybody corporate should approach any issue by saying, well, the average person wouldn't get offended or wouldn't get affected, so therefore you shouldn't either. So I think particularly in the smaller strata communities that we have, if you've got a scheme of 20 or 30 lots, for example, to me, it's not that hard to take into account people's individual circumstances. At law, sometimes that might be harder when you're dealing with the whole population of the state, but in strata, I don't think it's necessarily that difficult.
It is, and this is one of those areas in which strata sort of veers into climate, and in fact there's quite a few areas in which that might actually be a future podcast, in where strata veers into climate and climate change. I think we're seeing La Nina weather patterns, meaning more rain and more rain, changes to air temperature, changes to humidity as a result. Certainly recent years would bear that out. And I guess that means, Frank, the conditions have been ripe for mold infestation.
Yep,
Mm,
absolutely. And,
mm,
it's one of those things that it does pop up pretty regularly because you only
mm.
need a single rain event and some sort of, flat roof. My father was a insurance assessor, and he always used to hate flat roofs because they always leaked. It would pool somewhere and it would come down through the roof. So anything with a flat roof is liable at some stage for the water not to be able to escape and leak, and that's going to lead to things like mold. Because if as we came up with the idea for this topic, it's over, I'll say, the decades. There's been lots of mold conversations, but never have we encapsulated them into one particular webinar, and here we are today.
Absolutely. And I think, as is the case with most things which happened in Strata, mold's an issue which can be both can have a few different impacts, but when you put it into a Strata context, it gets exacerbated because of that high density, high interaction, high contact. And really, when we talk about mold, Frank, I think we're talking about water ingress as well. So we're put up. We did a webinar slash podcast on water ingress, so we'll look to be putting that link in there for you. Let's rip into it. So why is it an issue? Well, I think we've touched upon this a few times already, and we'll sort of delve into this a bit more. There is the aesthetics, which can't be underestimated, I don't think. You've got a huge black thing on your ceiling. You can't be happy with that. Health, which we'll delve into that one in just a moment. Property values, I think, is the other big one here. And where that becomes a particularly big issue is in relation to the ability to let out a lot. I know I have one story in that regard. Frank, you have one too?
Absolutely. And this was really my first proper exposure. We were acting for a body corporate up in North Queensland. And that was one where person in the unit probably had some mental health difficulties, to the extent that they stayed locked inside 24/7 and ran the air conditioner at 17, 16 degrees or whatever it was permanently. And it became an issue when, probably about 2 or 3 weeks after this behaviour started, the whole floor of this particular building just smelt horrible. And when the body corporate knocked on the door and person invited them in, the room was basically saturated wet and covered with a type of mold, blue or green mold, but the more dangerous one. And this person hadn't even realised it.
Right.
It was just, World War III in a sense. And in terms of that, danger to everyone else in terms of spores and whatever it might be. So that was panic stations for a bit. I mean, that resolved itself, thankfully, with everyone working together without the need for any judicial intervention. But it was like, okay, right, that's crazy.
Yeah. And like just a short story for me, I had a client recently, body corporate, and they were sort of trying to enter into a settlement, if you like, with a lot owner. And one of the components of the settlement was the fact that they had not been able to let out their lot for, I think, a year or something approaching a year because it was not inhabitable due to the state of it. Water ingress, yes, but mold was absolutely a part of that. So you can't underestimate those kinds of impacts. The other impact, Frank, that's now going to emerge, you and I think, is mould in relation to a hazard under the legislation.
Yes, and this is back to, I suppose, our smoking pobinar. There you go. Podcast slash webinar, whatever you want to call it.
Pobinar, yes, I love it.
About the Article decision, where we'd all looked at section 167 in the context of what a nuisance was in relation to smoking. And an adjudicator said, well, hang on a minute, let's look at the back half of that. And it says nuisance or hazard, and found that smoking was a hazard and therefore imposed some restrictions around people using their balcony to smoke. When that was the first time that appeared. And now the question, definitely, and I've done advice on this just recently as well, is what else could be a hazard?
Right.
And we spoke about, when we did our webinar, we were talking about barbecue smoke, vaping, et cetera. Could mold be a hazard? I think absolutely, without any doubt at all. So I think that could be an interesting one to see what flushes out over the next 12 months in terms of adjudications.
And definitely, as always, it's about the evidence base for these sorts of things. It's one thing for you and I to say, well, mold can be dangerous, but you need to actually have some objective basis on which to say that. And there, you would think that there would be some objective information about that out there. All right, let's investigate a couple of scenarios then, Frank. And I've already got one question there which poses a scenario. Some of this may cover that. But if not, we will get to that one. So scenario, there's mold on common property. That's a body corporate responsibility, right? How do we get it attended to, Frank?
Yes, let's start by the most important thing in these questions or conversations is what type of format your plan is. So we have building format plans, which are also known as BUPs. You know, BUP is how they used to be registered. You could tell by the lot on plan description, but that's not the case anymore. Every property in Queensland is now registered on a survey plan, and it's a different type, building format or standard format. And I suppose the simplest version, building format means that the body corporate's got a hell of a lot more responsibility in relation to areas external to the lot, subject to some carve-outs, whereas standard format, or what used to be known as group title format, usually the property is the responsibility of the outside of the property is responsibility of the owner, subject to whether it's shared with other people's use and enjoyment. And I suppose, Chris, back to your days as commissioner, I think this remains number 1 or 2 in terms of disputes in the commissioner's office and questions every year, and has done forever.
Always, and there's a methodical process that you go through for that. And I think you were outlining it really well there, Frank. You start from the generally accepted position, and then you look for the carve-outs and the exceptions, and then you apply the particular circumstances. So in this particular case, there's mould on common property. Let's assume, for argument's sake, it's building format plan, which is typically a high-rise. That's typically built, not always, but typically. So there's mould on common property. It would fall to the body corporate to attend to that, subject to there being no other variables that made it a lot owner responsibility. Then you add in the caretaker. So a caretaker is engaged to do certain duties in relation to common property and to lots under certain circumstances. So you would think on one hand, Frank, the caretaker would be responsible for the mould removal, but maybe not so fast. It depends on not only contract terms, but if we've already established that mould might be a hazard, then wouldn't it also be a hazard to a caretaker as well?
Yep, absolutely. And then we lurk in, and this is, I suppose, how people try to make Strata simple, and it's not. So we're sitting here just having a live chat about an issue that might come across our desks, and Jude's question there probably relates to it. A body corporate can be a PCBU under the Work Health and Safety Act. So a PCBU has a responsibility not to expose people to issues that could cause them harm or danger. Yep. So what type of mould is it? And I suppose, what does the caretaking agreement say? How high is the mould? It's like those sort of things, you know, and that's the grey which we both play in all day, every day. So it certainly starts fundamentally, there's something on common property that needs to be fixed. Body corporate's got a statutory obligation to keep common property in good repair and condition. Is allowing something to go mouldy that? No. But the question is then how it gets fixed and who fixes it.
What about another complication, Frank, which is that in removing the mould, the product / material / method used to remove the mould of itself causes runoff or other problems. That's another complication, isn't it?
Yep. And, you know, it's, I think, and Chris, this is one of your ones as well. You said, I mean, there's 50-odd thousand bodies corporates in Queensland. Perhaps 45,000 of them cruise through every year, doing most things right, some things wrong, and no one quibbles, and that's fine. And then for the rest of them, there's these sort of issues where someone gets upset about something not being done the way it should be, and we've got a bit of a legislative breach in some way, shape, or form. So I suppose, and Jude's question there is, you're in the middle of the standard module, 30 townhouses. Is the body corporate responsible for mouldy downpipes of shared gutters? My take on that, so standard module isn't really relevant in this one. Standard format or building format would be what you'd want to get to. To me, a default position, again, if we're shooting from the hip, which is what we are without looking at plans and CMSs and exclusive use areas and all that sort of stuff to be conclusive about it, if a piece of common, my default position is this: if a piece of common property is shared between multiple owners or provides benefits to multiple owners, usually that's going to be the responsibility of the body corporate to maintain. Because where I think the legislation comes from is it doesn't want to sit there and leave people to figure out their own issues if one person doesn't maintain something that then affects another.
Yep.
Particularly in relation to common property infrastructure like a gutter. So my answer to you, Jude, is probably regardless of format, a shared gutter is probably going to be a body corporate expense, but again, you need to check that for sure.
And Jude, it depends upon where it came from, where it all started, because we don't know, for example, if there was damage caused by an owner or an owner's failure to maintain their lot, which contributed to that. And of course, the very next question you're going to ask us, Jude, is how do I prove that? You prove that with an expert, somebody who knows what they're talking about. So not a bush lawyer, not an amateur engineer, but a proper engineer or a proper plumber or whomever. Somebody who is not just qualified to be able to say so, but somebody who, if their opinion is challenged, can actually defend it because they have the necessary expertise and qualifications to defend it. That's what you want.
Could not agree more, Chris. Absolutely. Yep. Because it's very, very easy to throw allegations around about these things. It's a lot harder to prove them conclusively. And that's what it needs to be. Yep. The balance of probabilities are that is what the cause was.
That's what the adjudicator will ultimately look for. The adjudicator will look at the reports and the professional opinions presented to them, and they'll go, well, there's opinion 1 from that person, and I look at their qualifications and I look at what they said, and there's opinion 2 from this person who is an engineer, but that person isn't. Well, there you go. Speaking of adjudicators, we do have an adjudication order to share with you, and we'll put up that link now. So this is for a scheme in which Mould, I think, and we were having a vigorous discussion about this just before we went on air, Frank. I think we came to the conclusion that in this case, Mould effectively is a consequence of the body corporate's failure to maintain.
Yeah, and I mean both of the adjudications we're talking about today have a similar sort of factual matrix, but have gone completely different ways, which again reflects the ability of adjudicators to make orders that are just and equitable in the circumstances. They're not bound by precedent. Inside that office, they can come up with different decisions based on relatively similar facts, with how the vibe, for want of a better phrase, of the facts were. So this first one was, again, mould in the roof. Owner claimed for a whole bunch of repair works, including some things, fans and all that sort of stuff. And the adjudicator did order most of it to be reimbursed, but not all of it, because the adjudicator was satisfied. And this is a really interesting thing. In the Commissioner's office, normally, there's no ability to award damages. So it's very rare to get, you might get an award for costs in there if a proceeding's been vexatious or misconceived, but there's no real scope to sue someone for damages. Under Section 281 of the Act, an adjudicator does have the ability to award repair costs as an amount if the body corporate has breached the Act or the CMS. So in this first one, the adjudicator was satisfied that had happened in certain respects. And the conversation Chris and I was having is that the mould, so when you look up and you see mould in your roof, that is a consequence, actually, and this is the thing that people need to prove rather than just say it's the case, that is a consequence of some failure in a roofing structure or waterproofing membrane or whatever it might be upstairs. And so the body corporate's got statutory responsibility for maintaining roofing structures and for maintaining membranes and all those sort of things. So this is the expert bit, is that going in there and saying, I've got mould in my roof and that's the fault of the body corporate, without someone who's an engineer or water leak expert or whatever it might be to say, well, yep, I've gone up there and looked in it, and guess what? The membrane is completely cactus and it's going to leak like a sieve from now evermore. It needs to be fixed. Bang.
Because, Frank, it is possible that the mould is actually from something else. Not.
You go to my air conditioning story. You leave the air conditioning pumping 24/7. That can happen internally without any body corporate issues.
So I think that answers, Chris, your question. The frame leaked into a roof. There's body corporate responsibility. Would internal mould as a result of the leak be body corporate responsibility? And we'd say yes, provided that there is some objective evidence that common property was not maintained properly, and that the mold is a direct consequence of that. I'm assuming you would get one expert to say the two things at once. I'm assuming you would anyway. Maybe not, but who knows? Let's try scenario 2 then, Frank. So there's mold on the roof of my lot. So that's a body corporate responsibility again, right?
Again, this is this plan type. So if you're a building format plan, potentially, because at that stage, your roof stops, halfway through the roof, and above that then is the body corporate or the other lot owner. If you're a standard format plan, that building envelope is quite possibly yours. And particularly if you're a complete standalone townhouse, there's the magic word that everyone's looking for. And this is the thing, people think that townhouses are all standard format plans. They're not. A lot of them can be building format plans. It's really back to the developer to make a choice when they're allocating these things or registering them. But if you're a standard format plan and you're a townhouse and you're a standalone townhouse on your own block, your own little site of land with no adjoining properties, then almost certainly that's going to be your problem.
Almost certainly.
Not the body corporate's problem.
That's right. There would be, we've just put up a link to an order. So this is actually the other side of the coin from the order we were just discussing. So this is a circumstance in which the adjudicator declined to make an order for damage which led to mould on the basis that the adjudicator could not be satisfied that the link was established in the first place. So this again comes back to the point, we're hammering this point a lot, just because you can see the mould and you know it's problematic, it does not follow that it's going to be the body corporate's responsibility. It must be evidenced that way. And then there are complications through exclusive use bylaws, potentially. And then, Frank, there's the body corporate's general responsibility to act reasonably. So my question to you, would it be open to the body corporate to make a reasonable decision about mould treatment if it's a health issue, even if perhaps technically it wasn't their responsibility under legislation?
I think it gets dangerous to start spending. Yeah, well, maybe. I like saying yes or no.
Okay, let's present the scenario then. So we've got a 10 lot scheme. Six lots. 6 out of the 10 have got mould in the ceiling. They're all tenanted. And you've got a scenario in which it is reasonably clear it all started from one lot. And for whatever reason from that one lot, it has moved on or it's moved through. What about them?
Well, I suppose maybe what owners also have statutory obligations to maintain their lots. If the owner hasn't maintained their lot in a way that they should have, which has led to consequences that might be financial in nature to other people, then the body corporate can certainly step in to do what needs to be done. But it should be seeking to recover those costs from that person via the Commissioner's office. So, like for me, as much as the Commissioner's office is busy, my experience has been that if you go in there seeking something on an urgent basis, on an interim basis, and it is something that is required to be decided urgently, they can be extraordinarily helpful. We've had a couple of, still doing them, alternative insurance applications, which have been turned around, in 24, 48 hours because they're all urgent. They get done. Get the odd interim order that gets done. So I suppose what's acting reasonably in these things, and I suppose legal principle number one, you've got an obligation to mitigate any loss. The moment a body corporate becomes aware of something or someone not doing what they should be doing, it's the time to act then rather than leave it sit for 6 weeks and allow it to continue on. And I suppose this is a little bit about Len's question there. What about if there's water ingress to a lot owner claims there's mould and just charges on to do what needs to be done? Who's bearing the costs of that? And I think if again, we're back to this causation element and back to proof, because when you look at that second decision, which is Hacienda, which we put up there, the adjudicator specifically noted that there was no proof provided by the owner. It was just the owner saying something. So I think in response to your question, Len, it's really down to what's the evidence about what the cause of that mould actually was. And this is where a lot of these things, because the legal principle is relatively simple. If the body corporate's in breach, then the body corporate's responsible. But proving that breach is the issue.
We are rapidly running out of time, Frank. I just want to really touch upon really quickly a point that I know comes up in this discussion about mould a lot, which is where the lot is uninhabitable and therefore can't be let out. So loss of rent. And so the bottom line there is the Commissioner's Office does not have any jurisdiction to deal with loss of rent. The adjudicator only has jurisdiction to deal with damage. Loss of rent is not damage because we're talking about literal damage here. We're
It's
not talking
damages, not
yeah,
damage.
yes, there you go. Very important distinction. So if it's a loss of rent situation, then without going into all the gory details, effectively you're looking to dismiss that application out of the Commissioner's Office and take it off to court.
Yes.
So that is not cheap, not cheap. I want to get to a question there from Thurston. I know, Thurston, you're becoming a bit of a regular. Thank you. So my unit has 2 square metre ceiling mould yet to be repaired from pre-Christmas. If spores affected my breathing on a recent hiking trip, how to get assessed, how to approach the committee. I'm going to take a few leaps there, Thurston, and assume that what you're saying is the mould in turn has affected your breathing, which in turn has had some impact upon your day-to-day life. Maybe you can't work, or there's been medical expenses. That's probably more likely. I would think, and I'll hand over to you in a minute, Frank. I would think your first step is to get a medical report. That's a no-brainer, Thurston, because you can't just stand there and say those spores affected my breathing, unless you're a doctor. I'm assuming you're not a doctor, so you will need a doctor to evidence that. And then you approach the committee. What are you approaching them about? What do you want them to do, Frank?
Yeah, I mean, to me, that's like personal injury territory. It's medical evidence to start with, something that proves that the link between the two. And then it is, what do you actually want with it? Like, to me, and the other thing is then back to that mitigation. So if you've got mould in your ceiling and it's been there forever, one of the things you need to be doing is putting the committee on notice of that and dealing with it. So back to Len's question before, an owner's gone and done their own thing. My question would be whether that owner approached the committee and the committee ignored it, or whether they've just charged on regardless because of that particular fear. Could you have mitigated your loss by moving into a hotel room for a couple of weeks and saying to the committee, you got to do this? And I know that this is all theoretical. So, but it's not just a matter of shooting first and asking questions later. It's sort of being a considered step-by-step process and allowing the committee a chance to make a decision, because acting reasonably doesn't mean usually you've got to jump the minute you reach out.
That's right.
But you've still got to move, I suppose, at a reasonably proximate pace relative to the question that's been asked or the issue that's in front of them.
I like the way you put that, Frank. Yeah, that's a good one. And Debbie, your question, what about loss of mortgage for the property being unlivable? Same thing, Debbie. That's not something that can be handled by the Commissioner's Office. You would need to seek legal advice, and that matter would have to be pursued through civil action, I think, Frank.
Yeah, mitigate first. So is there a cause that can be done through the Commissioner's Office on an interim basis that might be over and done in a week or two? Maybe you even appoint someone like Chris as an administrator to drive a particular process if needs be, and that's the order you're seeking. But yeah, there's some steps beforehand rather than just suing the body corporate.
We've just about run out of time. We didn't even get to the final point today, which is about preventative measures. I mean, we bang on about this all the time, but prevention is so much better than cure in Strata. And so this is where maintenance, regular schedule of maintenance becomes really important. Also, a really good time to remember that the body corporate has power to enter a lot under certain circumstances, doesn't need permission, doesn't need consent for that. And so if there is a concern about mould forming as a result of something going on within the lot, and the body corporate gives proper notice, they can enter that lot to investigate that. But I think your point, Frank, is the best made point out of today's discussion, which is that you must put the committee on notice about the issue so that action can be taken. You can't just charge off on speculation on this one.
And committees being put on notice should then not ignore it and do something about it, which is a la Artique. So again, the adjudicators, right, I think, are starting to get a little bit more pushy towards committees. You're there. It's not just a token appointment. You might have to actually do something. So if a committee's put on notice about something, do something about it. Don't just park it and leave it for the next committee meeting in 3 months' time.
Absolutely. Look, and on that note, that's all the time we have for this week. You can find the notes and the links we've mentioned at hineslegal.com.au. You can find me That's Chris, at stratasolve.com.au, and you can find him, that's Frank, at legal.com.au. All those things you can find. Until next time, Frank, we won't insult David Bowie next time.
Find some other
Anyway.
dead celebrity.
Yeah, maybe. Yeah. Until next time, everyone, thanks again for tuning in. Much appreciated.
See you, everyone.